Hi there. In this video, we are going to be looking at the tort of malicious prosecution, and I will also be defining what the tort is about. We'll also proceed to look at the ingredients or the elements of the tort of malicious prosecution, and in between there, we'll also look at a number of cases to illustrate these elements in motion, and of course, we'll also be discussing the principles that generally govern the tort of malicious prosecution. Hi there, my name is Matiaba Conrad. I'm a lawyer and a private law tutor. And before we start on our class, I encourage you to subscribe to my channel. Just below the lower hand side of your screen, there's a red button. Just click on it, turn on your notification, and also share this video with your colleagues so that they're also able to benefit. And then also, of course, like the content in case you find it interesting. So let's jump right away into our class, but it's also important to remind you that in case you're a student and you're having challenges in your law school, you need that extra polish, that extra tutorial classes, please contact us. We can always jump in to help you. Our numbers are down in the description box. So let's start right away by looking at the definition of malicious prosecution. So from the onset, it's important to know that this is a tort under tort law. And by definition, basically, one of the tactics you can use is to actually combine the elements of the tort to actually define what the tort is about. So basically, malicious prosecution is a tort in which the plaintiff proves the following. One, that he has sustained damage, okay? That the defendant prosecuted him, that the prosecution ended in the plaintiff's favor, and that prosecution lacked any reasonable and probable cause, and that the defendant acted maliciously. Now, when we talk of maliciously here, what we mean is that the defendant actually acted with some other motive other than the desire to bring justice to a person whom the accuser believes to be guilty. So basically, that's what the tort of malicious prosecution is about. Now, whereas actually majority of these torts normally are brought against the state or government or police. However, in Martin versus Watson, it's a case of 1996, East Africa, page 74, the House of Lords actually reaffirmed that a private person who sets the law into motion may actually incur liability. Okay, so you can also actually sue a private person who has brought criminal proceedings against you under the tort of malicious prosecution. Now, it's also important to note that the action for malicious prosecution being an action on the case. What do we mean by an action on the case? Basically, an action on the case is an action brought to recover damages from a person whose actions have resulted indirectly in injury or loss. Okay, so action on the case is a form of action in itself. So the action for malicious prosecution being an action on the case, it is essential for the plaintiff to prove damage. So you always have to prove damage. You have to show that a certain degree of damage has been incurred for you to succeed to sue under malicious prosecution. Now, it's important to note that actually damage can be looked at in three classifications, or it can be looked at in three ways. These include: one, malicious prosecution may damage a man's fame. So the damage could actually be to your fame. Or secondly, the safety of your person. Okay. Or thirdly, the damage can also be the security of your property by reason of you incurring an expense to repel an unjust charge that was actually brought against you by another party. Now, under the first head, which is actually damage to a person's fame, the nature of the offense, okay, he or she is charged of, and the punishment it calls for will determine whether the plaintiff's fame is injured or not. So here we look at the nature, okay, of the offense. It's really very important. Let's say, for example, if you charged, let's say, with an offense maybe of theft or murder, okay, there's that stigma that is naturally attached, okay, where the law visits, for example, an offense with imprisonment or maybe extremely heavy punishment. But where the offense, for example, is punishable by a fine, okay, the plaintiff will only rely on damage to fame if that offense with which he is charged is necessarily and naturally defamatory to him. Okay, so it's important to note when we are looking, we'll also examine the type of offense. Okay, let me share with you about two cases to actually throw more light on this aspect. I encourage you to look at the case of Whiffen versus Bailey and Ramford, UDC. It's a case of 1915, volume 1, KB, page 600. And basically here, a charge of wrongfully pulling the communication cord in a railway train, court held, doesn't necessarily affect the fair fame of the accused and will not ground an action for malicious prosecution under that first head. Okay, but please distinguish Whiffen versus Bailey and Ramford UDC from, for example, Rayson versus South London Transport Company. It's a case of 1893, volume 2, Queen's Bench, page 304. And basically in this case, the plaintiff was charged with deliberately traveling on a train without actually having paid his fee. So he hadn't paid his fee. Such a charge, okay, would ground an action for malicious prosecution and could damage a man's fame. Very important to note. Also of interest to you, you can look at the case of Gregory versus Portsmouth, reported in CC 200, The Times, that is on the 2nd of February. Basically, in this case, the House of Lords held that malicious prosecution, or rather malicious institution of internal disciplinary proceedings, could actually, okay, give rise to a claim for damages for malicious prosecution. So even in internal disciplinary proceedings, okay, you could sustain a suit for malicious prosecution. So please note that. Now, under the third head, which is the security of one's property by reason of you incurring expenses in repelling, let's say, an unjust charge that has been brought against you, this will ground where the plaintiff has actually incurred costs in defending himself. So you must have incurred certain costs. Maybe if someone brought a suit against you, costs such as litigation costs, costs to pay the lawyer, expenses, transportation of witnesses, or any other types of costs, then definitely your tort would be grounded. So the aspect of damage would be sufficiently proved. Now, let's assume that there is actually that damage, okay, as demonstrated under any one of the three classifications we have just looked at. The plaintiff then has to proceed to prove the following elements. So one, they have to prove that there was actually a prosecution. Secondly, they'll also have to prove favorable termination of the prosecution, that actually the prosecution terminated in your favor. And then also thirdly, they have to prove lack of reasonable and probable cause in the termination. And then also finally, they have to prove what is known as malice. So we are going to examine these four elements a little bit more in detail, looking at some of the principles governing them and also discussing some of the interesting cases to actually illustrate them in motion. So the first we are going to look at is the first element is that the defendant prosecuted the plaintiff. So you have to prove that actually the prosecution was against the plaintiff by the defendant. Now it's important to interrogate a little bit more what we mean by prosecuted, okay, which comes from the word prosecution, which basically means the institution of criminal proceedings involving an accused person in the courts of law. Okay, so there must have been those proceedings that were instituted against the plaintiff now who is bringing a suit of malicious prosecution. Okay, now a person who brings a private prosecution is of course obviously a prosecutor for this purpose, and so is a police officer who first lays a charge against you, okay, that is in criminal proceedings. I encourage you to look at the case of Martin versus Watson, a case of 1996, AC page 74. And basically here the House of Lords held that it is not necessary that the defendant should be the prosecutor in any technical sense. What matters is that he should, in substance, be the person responsible for prosecution being brought. Okay, so it's important to note that really. Then let's now proceed to look at the second element, which is that the proceeding stroke prosecution must have been terminated in the favor of the plaintiff. So you must actually have won, okay? Not necessarily winning, but the proceedings must have ended in your favor. Okay, now this is really very important to examine, and there are a number of principles that I want us to discuss about. Now, the plaintiff must show, for them to succeed under this tort, that the prosecution ended in their favor. Okay, not necessarily winning the case. Okay, but it is immaterial how this actually comes about. Okay, whether by a verdict of acquittal, meaning that you may have gotten an acquittal, or by discontinuance of the prosecution by leave of court, or even by quashing of the indictment for a defect in it, okay? Or even because the proceedings were coram non judice. Coram non judice basically means legal proceedings that are outside the presence of a judge. So it really doesn't matter. The proceedings may have been outside the presence of a judge and they ended in your favor, or it could be because the prosecution ended by way of discontinuance, or maybe prosecution rather court quashed an indictment for a defect that is in it. It really doesn't matter. All these elements will all demonstrate that actually the prosecution terminated in your favor. Now, or even it could be by what we call a non-suit. Now, a non-suit basically is termination of a legal action without an actual determination of the controversy on the merits. Or it could be that actually the case came to an end, but court even did not look at the controversies or the issues that were raised. It still does not matter. The suit still ended in your favor. Now, there is something that has been a bit controversial, and that is what we call nolle prosequi, okay, which basically means staying by the Attorney General or prosecution in the Ugandan context of proceedings on an indictment. So nolle prosequi, this happens where prosecution actually withdraws, or the state withdraws a certain criminal a suit that has been brought against you, or a certain charge. So can we say that if there is a suit has ended by what we call nolle prosequi, can we say that actually prosecution has terminated in the plaintiff's favor? Now, there has been a lot of controversy on this aspect. There are some cases actually that where this aspect was actually left open, such as Goddard versus Smith, which is a case of 1704, 1 Salk 21. This aspect was left open. Court did not openly actually conclude on the same. But however, when you look at other jurisdictions, such as in the USA, this aspect has been litigated over so many cases, and the balance of cases, or majority of them, cases have actually held on this question that the effect of nolle prosequi is a sufficient ending of the prosecution, that even if there is nolle prosequi, or even if prosecution or the state withdraws charges against you, this is sufficient. Okay, it's a sufficient ending of the case, and as such, nolle prosequi is tenable under the second element of the case being terminated in your favor. And there are a number of cases I can encourage you to go and look at. Look at the case of Gilchrist versus Gardner. It's a case of 1891, 12 NSW Law Rep, page 184. And you can also look at the case of Khan versus Singh. It's a recent one of 1960, volume 2, WIR 441. All these cases support the position in the American jurisprudence that actually nolle prosequi is a sufficient termination of the case. It's also important to note on this aspect the case of Raylands versus Kennedy. It's a case of 1784, 1 Wheels 232. Basically, here court was holding that if, for example, a conviction was entered and you appealed, but on an appeal it was actually overturned, court here was trying to say that you cannot say that prosecution has ended in your favor. Okay, but it's important to note that this Raylands versus Kennedy position is actually old law, and the new position now, which cements the principle that if, for example, a conviction is entered and you appeal, okay, and in the appeal you are actually successful, then a suit for you can bring a suit for unlawful prosecution, and court was holding that it's actually tenable. That's now the new position of the law, and for purposes of that position, please, I encourage you to look at the case of Hammond versus Smith. It's a case of 1938 SC, page 305, or you can also see the case of Berry versus BTC, a case of 1962, volume 1, Queen's Bench, page 306. All these two cases actually support the new position that provided you appeal and on appeal a conviction is overturned, then a prosecution or rather termination would have ended in your favor, and as such you can sustain malicious prosecution. So that is the new position. Please disregard the position in Rylands versus Kennedy. It's old position and it's no longer tenable under the law. Let's now proceed to look at the third ingredient of this tort, and that is that the defendant lacked reasonable and probable cause to institute the prosecution. So you also have to prove this element, and basically the burden lies on the plaintiff to prove the reasonable and probable cause. And reasonable and probable cause was actually defined in the case of Edrisa Semakula versus the Attorney General. It is CS number 6 of 1975, and I encourage you to look at the judgment of Butajira. And basically the judge defined reasonable and probable cause to include an honest belief in the guilt of the accused based upon full conviction founded upon reasonable grounds of the existence of a state of circumstances which, assuming them to be true, would reasonably lead any ordinarily prudent and cautious man placed in the position of the accuser to the conclusion that the person charged was probably guilty of the crime imputed. So basically that's what we mean when we talk of reasonable and probable cause. But in summary, basically what we mean by reasonable and probable cause is that there must be sufficient grounds for thinking that the plaintiff was probably guilty of the crime imputed. So basically reasonable and probable cause basically is about sufficiency, or rather reasonable grounds. There must be those reasonable grounds for one to think that actually the person has committed the offense, okay? And if those grounds are not there, if you don't have reasonable or sufficient grounds for you to honestly think that actually a certain crime was committed, then in law we say that the defendant lacked reasonable and probable cause. Let's now proceed to look at the last ingredient, which is that the defendant acted with malice. And basically here what you have to know is what we actually mean by malice, and malice may refer to some other motive by the defendant rather than the desire to bring to justice a person whom the accuser honestly believes to be guilty. So basically that's what we mean when we talk about malice in that perspective. Now, an interesting case to illustrate this element of the aspect of malice is the case of Edrisa Semakula versus the Attorney General, the citation which I shared with you earlier. And basically the brief facts of this case are very interesting, and they actually illustrate the aspect of malice. Now, in February 1974, Semakula traveled to Jinja to buy sugar for the society, and while in transit, he was arrested by the army men, that is the soldiers at the time, who closely interrogated him. He was able to prove that he had lawfully purchased the sugar, but the army went on and arrested him and took him to what is known as Gaddafi barracks, where he was actually detained for 5 days. He was beaten and detained for a further 3 days at Jinja police station. Now, he was then subsequently charged for the offense of hoarding sugar, and he did not receive the sugar back. So the sugar was taken, he never got the sugar back. The government, of course, later on admitted conversion, and the plaintiff was released on bail, and the charge was subsequently later withdrawn by police. And court went on to hold that one, that malicious prosecution was tenable. Secondly, that to succeed with the tort of malicious prosecution, the plaintiff must prove one, prosecution; secondly, termination of prosecution in the plaintiff's favor; thirdly, the lack of reasonable and probable cause; and then lastly, malice. Court actually went on to observe that actually in the premises and from the facts, there was a clear indication of malice, and that the army men were actually not acting genuinely. And from the facts, you can clearly see that actually Edrisa Semakula had gone on to prove that actually the sugar was his and that he had purchased it. He went on to explain himself, his documents were genuine, but however, the fact that the army men insisted on still arresting him even without any other reasonable cause was all an indication and pointed to nothing else but malice. So if you're able to prove those elements as shared above, then a suit for malicious prosecution would be tenable. So basically that's it for our class today, and please encourage you to subscribe to my channel and also like and share with your colleagues, and please ensure that you contact us in case you need help for private law tutorial sessions. We are able to help you. These private tutorial sessions have been proven to work, and students who are on our program have been continuously proven to outperform their colleagues, and many of them have really emerged at top of their class. Low grades really matter. It's really very important that you ensure that you have good grades, and it's important you really work on them from an earlier stage. Do not let yourself slip into having bad grades, as this would really be catastrophic to you in the long run. Thank you very much for listening in. We meet in another class. Bye-bye.